Well, breaking news coming in at this point in time. The Supreme Court has held that the coal block allocation made from 1992 onwards by the screening committee, no objective criteria was in fact followed, and the allocation was in fact done in a casual manner, but cancellation is subject to further hearing. The Supreme Court has in fact pronounced its verdict on the issue relating to the cancellation of coal allocation blocks and to deallocate those blocks which did not have environmental clearance. Remember, the Supreme Court had earlier also said that huge investments by firms cannot be a ground for not cancelling licenses. However, at this point in time, the Supreme Court has said that cancellation, the subject of cancellation, is in fact going to be postponed to a later hearing. At this point in time, the breaking news that we are getting from the Supreme Court is that the Supreme Court has held that the coal block allocation made from 1992 onwards by the screening committee, there was in fact no objective criteria that was followed, and the allocation was in fact done in a casual manner, but cancellation is going to be subject to further hearing. This is in fact the latest information that we're getting to you from the Supreme Court. This is after the court had in fact contended that huge investments made by firms cannot be a ground for cancelling licenses. The Supreme Court has pronounced its verdict on the issue relating to the cancellation of coal allocation blocks, and of course the decision to deallocate those blocks that do not have environmental clearance, and the cancellation of the blocks that in fact do not have environmental clearance is going to be a subject of further hearing. All allocations made by the 36 screening panels have in fact been held as illegal by the Supreme Court. Supreme Court holds the coal allocations made illegal. All allocations since 1992, the Supreme Court says, are in fact illegal, further stating that no objective criteria was followed for allocation, and just the fact that huge investments have been made by private companies is not a ground for cancelling licenses. It cannot be held as a ground for cancelling licenses. Supreme Court there coming out and saying that all allocations made after 1992 are in fact illegal and no objective criteria was followed. However, the Supreme Court, while maintaining that allocations were done in a casual manner, have put the issue of cancellation subject to a further hearing. My colleague Jaskirat Singh Bawa is now joining me live from the Supreme Court. Foremost, Jaskirat, crucial judgment there by the Supreme Court, but at the same time the issue of cancellation being subject to further hearing, Jaskirat.
Well, that's correct. One people can compare this to the 2G judgment, or one can feel the impact of the 2G judgment over here. What is being felt is that the Supreme Court, while holding these allocations which in 1993 as illegal, arbitrary, and all the 36 screening committees that sat to make these allocations acted in an arbitrary manner which is not transparent. All of those words that I just used are observation by the Chief Justice of India. However, perhaps understanding that the economic impact that it would have, because most of these allocations were made years ago and the process is already underway. So the cancellation is now going to be subject to further hearing. The bench is once again going to sit on the 1st of September under the Chief Justice of India, Justice Ruloda, who was the one in fact who delivered this verdict.
Well, absolutely, Jaskirat. This comes after a time when the Supreme Court had already contended that huge investments made by firms cannot be a ground for not cancelling licenses. So clearly this is in fact a very strong message that the Supreme Court has in fact sent out today, deeming all of these allocations illegal.
Well, that's correct, and the observations are very similar to what was made in the previous judgment with regards to the 2G. Now,
Jaskirat, stay on with us. We understand that Prashant Bhushan has in fact reacted to this particular judgment. Let's listen in.
सुप्रीम कोर्ट सुप्रीम कोर्ट ने आज एक बहुत ही ऐतिहासिक और महत्वपूर्ण फैसले में कोयले के जो ब्लॉक्स के जो एलोकेशन करे गए थे सन 93 से लेकर 2004 तक और फिर 2004 से लेकर 2009 तक सबको अवैध डिक्लेयर कर दिया। सुप्रीम कोर्ट ने ये बोला है कि चाहे वो स्क्रीनिंग कमेटी के थ्रू एलोकेशन करे गए हों चाहे सरकार के थ्रू पब्लिक सेक्टर यूनिट्स को एलोकेशन करे गए हों, सब में कोई पारदर्शिता नहीं थी, कोई सिस्टम नहीं फॉलो किया गया था। बिल्कुल आर्बिट्ररी तरीके से, बिल्कुल अवैध तरीके से, भाई भतीजावाद के संग इन एलोकेशंस को किया गया है। और इस वजह से सारे एलोकेशंस जो केंद्र सरकार ने किए थे, चाहे पब्लिक सेक्टर यूनिट्स के लिए, चाहे निजी कंपनियों के लिए, सबको अवैध डिक्लेयर कर दिया है। यस। और अब आगे इसका कॉन्सिक्वेंस क्या होगा, उसके लिए, उसकी सुनवाई के लिए, यानी कि जो कंपनियां जिनको लीज मिल चुकी है, जो वहां माइनिंग कर रहे हैं, उनका क्या होगा, ये सोचने के लिए कोर्ट ने 1 सितंबर की डेट लगाई है।
ये भी जानना चाहेंगे जो कैग ने असेसमेंट दिया था 1,82,000 करोड़, उस पर लगातार विवाद रहा, उस पर सुप्रीम कोर्ट ने क्या बोला?
नहीं, उसका अभी पूरा जजमेंट अभी पढ़ा नहीं गया है, लेकिन जितना पढ़ा गया कोर्ट में उतना मैं बता रहा हूँ। उन्होंने ये भी बोला कि जो अल्ट्रा मेगा पावर कंपनीज थी, जिनको की एलोकेशन इस आधार पर किया गया कि वो कम्पिटिटिव बिडिंग करके अपने बिजली के दाम सबसे कम से कम बिड करें, उस आधार पर जिनको एलोकेट करे गए कोल ब्लॉक्स, वो अवैध नहीं है। लेकिन उन कोल ब्लॉक्स में से अगर किसी कोयले को डाइवर्ट करने की परमिशन दी गई है, जैसे कि रिलायंस को दी गई थी, जिसमें कैग की रिपोर्ट कहती है कि सिर्फ उस डाइवर्जन से 29,000 करोड़ का नुकसान हुआ सरकार को, वो सारे उन्होंने रद्द कर दिए हैं और उनको अवैध घोषित कर दिया है।
सर इंग्लिश
कि जिन्होंने माइनिंग लीज जिनकी हो गई है, जो माइनिंग कर रहे हैं, उस पर क्या असर पड़ेगा, उसको कंसिडर करने के लिए सुप्रीम कोर्ट 1 सितंबर को सुनवाई करेगी। The Supreme Court, in a very historic judgment relating to the allocation of coal blocks by the central government between 1993 and 2009, has declared that all the allocations that were made by the central government, whether through the screening committee route or through the government allocation route to public sector undertakings, were all done in a totally non-transparent, arbitrary and sometimes malafide manner, and therefore all those allocations have been declared illegal and have been cancelled. Now, there are some companies which had been subsequently given mining leases and which had started mining in those allocations. To consider the impact of this judgment on those leases and the mining which has already been started there, the court has decided to have a further hearing on the 1st of September to decide that. The court has also held that allocations which were made to ultra mega power companies on the basis of competitive bidding of electricity rates, and who were given allocations on the basis of having bid the lowest rates for electricity to be generated from utilizing that coal, those allocations alone would not stand cancelled, but any diversion of coal from those ultra mega power companies to other projects of those companies, those have been declared to be illegal and stand cancelled, which includes the case of Reliance, which had been allowed diversion of coal to other company projects, for which the CAG had said that the government exchequer had suffered a loss of 29,000 crores.
Now what will happen? How will it be reallocated? What will happen to the cancellation?
Now, those which have been cancelled already, which have been declared to be illegal, if they have not fructified into a lease and their mining has not yet started, there nothing further needs to be done. Those all stand cancelled. But those which have fructified into leases, mining leases have been granted and mining is already being done, to consider what would be the impact of this judgment on that and what needs to be done to those particular cases. The court has